Good morning, good afternoon, good night, everyone. It's great to see you all. It's great to have you. Welcome to this week's Law Science event. I'm Daniel Hefke. I'm a JSD candidate at Cornell Law School. I will be the moderator for the session. And before turning to today's speaker, Ralf Michaels, I will briefly introduce the Law Science Project. We are an academic initiative coordinated by a group of JSD candidates who share the same belief in legal methodologies, which are often understood as a discipline distinct from science, so traditionally consisting of doctrinal analysis and normative questions. Through the series of interdisciplinary talks, we aim to show that legal research can really be improved and can benefit from interdisciplinary talks. We aim to show that legal research is better when it's provided with like systematic ways to approach questions. So if you want to learn more about the Law Science Project, please visit our website or join our email lists. One of the coordinators is gonna drop the link in the chat. And actually, that's a good point to introduce the other coordinators. So we have Simon Sun. He's an SJD at Indiana University Murrow School of Law. He's also the co-founder of this initiative. We have Marilyn Hush, a JSD candidate from the University of Virginia School of Law. Also a special shout out to the Legal Research Forum at UVA, which I also see here represented. We also have Vanessa Villanueva with us. She's a senior fellow and the chief editor of the Legal Method Lab and a former coordinator. And then we also have representatives at diverse other law schools in the US, such as Berkeley, UPenn, University of Illinois, Georgetown, University of Washington, Columbia, and Fordham. I see some familiar faces here, so hello to you and to everyone else. If you're interested in getting involved, we are always looking for new law science representatives. We also host a blog on legal methodology, the Legal Method Lab, for which we are currently still searching further editors. So if you are interested in getting involved by either becoming a representative or an editor, you will find a link in the chat for that as well. Great, but let's turn to our speaker for today. Welcome to Ralf Michaels. He has studied law in Passau, Germany, and in Cambridge. He was a fellow at Harvard, Princeton, and the American Academy in Berlin, and he has since taught basically everywhere, including the universities of Panthéon in Paris, Princeton, UPenn, Toronto, Tel Aviv, and the London School of Economics. For 17 years, he was a professor of law at Duke. And since 2019, he is now the director of the Max Planck Institute for Comparative and International Private Law in Hamburg. Ralf has made incredibly valuable and insightful contributions to the field of comparative private law and especially the methodology of comparative law. Thus, I could not think of a better speaker to start off this semester's Law Science Talks. The session today concerns the topic of decolonial comparative law and the need for a shift in how we study and compare private law. We will have time for Q&A at the end, so please prepare questions. The event will be recorded and uploaded to YouTube. So you can either raise your hand or you can write down your questions in the chat box, and then I'm happy to read them out for you. But now, without further ado, thank you so much for joining us, and the floor is yours, Professor.
Thank you very much, Daniel. Thank you, everyone else who organizes this. I think it's quite fabulous that not only that you have this initiative, but also that you use our newly found competence on bringing people together from different places to actually work together. I think in many programs of SJD, JSD programs, that can be immensely useful. I remember that at Duke, we had fairly few such students, and they often were not there. And so loneliness was great. And I think if you overcome loneliness through this already, that is something great. Thanks, Daniel, for saying you could not think of a better speaker than myself. I can think of better speakers, but they're not here. I'm here, and so you'll have to deal with me. I understand there's no formal introduction, but I would be interested if you could just somehow notion how many of you have a background in comparative law, any background. That is, either have taken a class or are writing in comparative law in the broadest sense. That's a good number of the visible people. I can't tell about the invisible people. That's a good number. The challenge, the reason I asked this is that our project on decolonial comparative law that I started and am leading together with Lena Salaimi, who is currently based in Oxford and mainly in Paris, has two directions really. And the one is an intervention within the discipline of comparative law. It is an attempt to see how insights from decolonial theory can be made fruitful within comparative law. There is in comparative law an ongoing, 30 years at least, I think, somewhat tiring methodological debate and self-awareness and self-critique that I have not found to be, that I found fascinating for some time and less so recently, because it's become something of a ritual that you have to complain about the state of methodological advances in comparative law. You have to complain about Zweigert and Kötz and the functional method, and then you write something why everything has to be different, and then you do whatever you do. It often has little to do with that critique. But anyway, so one of the approaches is an intervention within comparative law specifically, in the sense to see how can it be made decolonial. The other, of course, is an attempt to offer comparative law as a discipline to students of law in general and to students in decolonial law in the broader sense, more specifically. It is also to suggest that the way that we should study law is comparative, and that the way to study decoloniality in law needs to be comparative in some sense. And so those are really the two directions of this project. I have a presentation prepared. I'm going to go through probably half of it and skip the other half because it's fairly generic. We have an article that Lena and I wrote that I don't know if it was distributed beforehand, but it will be on my first slide, and anyone interested in that to look up the article. It's not very long and it is openly available. So I'll talk about a case study, and then I hope maybe that in discussion we can see whether we find common ground or not. So, but maybe before I start, one point about the role that we see for decolonial comparative law within these two directions that I just mentioned, that is an intervention in comparative law and an intervention in general legal studies and decolonial legal studies in particular. I think there's a common sense about law, that law, like any endeavor that we're in, has to be decolonized in the broadest sense. And some of the aspects of decolonization have to be to overcome a Eurocentrism and to overcome a narrow focus on our own northern world that is then universalized. So an openness to other approaches, to multitude, entanglements, etc. All of those things that are well known to you. Now, for a long time, comparative law offered itself as the discipline proposing to do just that, at least in the broader sense. That is, comparative law has always praised itself as able to overcome parochialism, nationalism, Eurocentrism, a sense of superiority, etc., by suggesting things like there are more than one ways of doing things in the world, doing things in law. We can understand ourselves better by looking at ourselves through the other, etc., etc. And so, in one sense, the problem that we face in law in general, that is Eurocentric, that is universalized, that it is colonial, finds a response historically already always in comparative law, which opens up to other perspectives, but only partly so. And the reason for that is that comparative law itself as a discipline is also colonial. That is, it's colonial in origins. Much of modern comparative law emerges from colonization, or at least from colonial thinking in the 19th century, some of it implicitly, some of it explicitly. By explicitly, I mean the use of comparative law, the deliberate use of comparative law as one of the tools of colonization. By implicit, I mean ideas in the 19th century about a certain internal hierarchy between less developed legal systems and more developed legal systems with European law at the top of this and non-European laws behind that, trying to catch up to the stage of Europe. And so it has been argued the process of comparison as a very process of ranking, of juxtaposing, of othering, etc. And so if we want to use decolonial comparative law as a way to help decolonize law, we first have to decolonize comparative law in order to turn it into a discipline that then can be of more general use. I think that's one reason why we think, Lena and I, that starting with decolonial comparative law, decolonizing comparative law does not mean ending with comparative law, but it means preparing comparative law to be that discipline that helps in this context. So that's basically what our project is. I'll say a little more about the practical parts of the project. I'll also advertise in the end, because we have a biannual workshop and conference, and we'll have the next one in Brasilia in 2024, and we'll look for papers on comparative decolonial property law, and certainly including it from SJD students working in those fields. And I'll say a little bit about that in the end. Let me try, if I succeed this time. Am I able to share a presentation, Daniel? Simon?
You should be if I make you co-host. Wait a minute. Let me find you. Okay, I just make you co-host, so you should be able to do it now.
Yeah, this should work. No, I only have to find my presentation again. Okay, I'm trying this now. Okay.
Yes, perfect.
Good. As I said, I'm not going through all of this, but I want to give you the case study because the case study might be of interest. And then I want to say some few things about the process of comparison and then open up for discussion, because in this project in particular, I'm interested in discussion almost more than in presenting this. So Lena and I established the Decolonial Comparative Law project in 2020. We had earlier thought about doing comparative religious laws and then figured that this is only part of a broader project of decolonial comparative law. And we have a website that goes with it that has a bibliography that may be helpful for you, both on decolonial theory more general and decolonial legal studies. None so far on decolonial comparative law. We're setting this up, but that might already be useful for you. And there you see a link to the article that we wrote. Is called Decolonial Comparative Law, Conceptual Beginning, and it is very much that. It lays out some beginnings of the research rather than a finite research program. We think that's in accordance actually with the demands of decolonial theory more generally. But that's where we stand. That's what you could look at least for our purposes. I know that Shirali Munshi presented in this series some time ago. We invited her, in fact, to the kind of pre-workshop that we had where we tried to set up our own project. And so this owes certainly something to her as well, to some other scholars, but we think it's sufficiently distinct to deserve its individual presentation and development. So when we talk of comparative law, to start with that first, what do we do in comparative law as a discipline? So comparative law emerges in the 19th century, at least as a modern discipline, together with other modern comparative disciplines. And most of those are genealogical in nature. That is, if you look at comparative literature, comparative linguistics, what they try to do is they try to explain similarities and differences between different languages as the results of common or not common ancestry. So certain languages behave in a certain way. Germanic languages can be traced back all the way to old Indian languages. Arab languages have different origins, and so we find differences between these languages, and we find also that these differences are caused by different origins. And then we have some explanations why some languages are better than others, and people with some languages are better than people with other languages. So anti-Semitism, as one example, starts, if you want, as a linguistic issue to demonstrate why Semitic peoples have inferior languages and therefore are inferior peoples, and so on and so forth. To some extent, comparative law emerges from that same dual focus on comparison, that is the finding of similarities and differences, and the explanation of that through genealogy. That is the impact of earlier laws on contemporary laws. And I would say those are two important parts today still of comparative law. The first would be the comparison between legal systems, or legal orders, or legal rules. That is the finding of similarities and differences and doing something with that. That is explaining them, explaining their origins, assessing them, finding which of those is superior, using them, for example, in forum shopping, etc. And methodologically, we have in comparative law different ways of doing that. One would be doctrinal comparison, where we compare just legal rules. Most people claim that nobody does that, although most people still do that. Some of that is culturalist comparison, that is somehow understanding laws as emerging from or representing broader cultures. That is by comparing Chinese law and Japanese law, we would really be comparing Chinese culture and Japanese culture insofar as they express themselves through law. And a third perspective of that would be functionalist comparison, that understands legal rules and institutions as responses to certain problems, social problems in particular, and explains them as such and compares them as such. That means first finds that different societies find different solutions to common problems, and that those solutions are then functionally equivalent because they perform the same functions. That is, compensation of accident victims through insurance schemes or through tort rules would be different ways of responding to the same problem, that is the compensation of accident victims, but they would be functionally equivalent because they perform the same function. They're equivalent in the way in which they perform that function. Another thing that functionalist comparison sometimes does is to see which law performs certain functions in a better way. All of those are really methods emerging from a European, from a global northern context. So they're different, obviously, and they fight along amongst each other, but they all emerge from a Eurocentric background, and they use Eurocentric concepts. Formal law is a very Northern European way of doing law. Culture is very much a 19th century romantic concept, at least insofar as it shapes a lot of comparative law, where we have a lot of essentialization of cultures, where we speak a lot of national cultures, Chinese culture, as I said, Japanese culture. The anthropological approaches to culture are often quite different, but they're marginalized in comparative law. And the functionalist approach also, I would suggest, is a very either instrumentalist or sociological approach emerging from specific northern ways of thinking. So that's one strand of comparative law. And it's very effective in what it does, but it's at the same time very, very Eurocentric in that way. A second one is the discipline of legal transplants, where we look in particular on the transfer, or the copying, you should really say, of legal rules, institutions, solutions, etc., from one legal order to another. So you have a law reform project, you want to reform your health insurance, and what you do is you look around the world, find models of health insurance, and adopt one or the other. And the third, and this goes beyond comparison already, is the examination of transnational law. That's the understanding of global law as both one and many. One in the sense that we have one law in the world, really, that all law hangs together in some way, but it's many because it is internally plural. And so comparative law would be the discipline to understand global law in its plurality. There's basically three traditional approaches to comparative law. And what I want to do is demonstrate in a case study how they play out and what problems come with that and then stop. So instead of giving a very brief introduction into decolonial theory and decolonial comparative law, I think you can find much of that in our article in our bibliography. I want to take the case study as starting point, maybe for a discussion to make some of these things clearer. The case study concerns the doing business reports. That is the project here of the World Bank, started in 2004 and ended in 2020, which tried to compare the ways, the ease in which it's possible to do business in, as it says here, 190 economies. Really, at first, it is 130 countries. So what do these people try to do? They try to understand how easy is it to do business in a given country, and to compare that possibility as among different countries. Why is that comparative? It's obviously comparative. We compare these different economies. Why is it comparative law? It's done by economists, and so in that sense, it's bad comparative law, not because it's done by economists, but because these economists didn't care very much about comparative law, but it is comparative regulation. It compares the regulatory field, and in that sense, it compares law. I was an advisor to the project for 2 years, and they asked me to look at specifically the law aspects, by which they meant adjudication. But I said, really, all that you're measuring here is law. Hiring and firing employees, renting factories, setting up a corporation, etc. All of that is law. Now, that's what started in 2004. It was ended, as you can see here, in 2021, because there were irregularities within the project. As you see here on the left, push staff to inflate China data. So a New York Times report suggests there was an intrinsic problem. On the right, you see a report from Africa that suggests this is actually great altogether, because this doing business report was terrible all along. And I think decolonial comparative law perspective would side with the latter assessment and say this is intrinsically problematic. Why so? What's the method? The method is essentially arises from a theory in comparative law, although this is a theory that emerged from economists. And the idea here was to say that legal origins shape institutions and institutions shape outcomes. What does that mean? In particular, in a colonial context, say these economists, it is to some extent a result of random distribution, whether an area was colonized by a civil law country or a common law country. So it was random whether a colony and later a country received a civil law system or a common law system. But that had impacts on the number of institutions that were built up, because they were built differently in civil law countries from common law countries. And now in return, we can measure how good the outcomes are from these particular institutions. So what we can do in this approach is we measure on the level of outcomes which countries are better, which countries are worse. From there, we can deduce which institutions are superior. And if we take all of that back to its origins, we can determine whether the civil law or the common law is better. And not surprisingly, these are Chicago economists. So obviously the common law comes out as superior in every regard. You can already see some of the clear shortcomings in this method, one of which is that what is being compared here in a context of Africa and Latin America is only the distinction between civil law and common law. So both colonial legal orders imposed on those areas. What is not being compared is autochthonous normative orders, etc. So this is basically the method. What is then done is the project set out a number of indicators. Starting a business, you can see here what they try to measure on the left: starting a business, getting electricity, dealing with construction permits, etc. And then they measure certain things. How many steps does it take for me to register a corporation? How many months does it take to fire a tenant who doesn't pay their bill? How easy is it to dismiss employees? when they set that up, the International Labour Organization complained at some point and said, look, you're actually giving high values to the breach of international labor law. And the economists say that that's, of course, because that's what we measure. We measure just how easy things are. So that's what the method is. They try to measure how well legal systems function on a map like this. So this is the map of the Legal Origins Project, and you can see the entire world is colonized. The entire world consists of English law, French law, some German law. China is German law, for example, some Scandinavian law, some socialist law, little pockets. So it's really a 19th century dream. There's more colonization than there was in the 19th century, right? Even China and Japan are actually German in this context. Because the focus is on the colonial origins here and not on the current law viewed independently. What is then done in this measurement is that the countries were ranked according to how well they did in terms of doing business. And you can see here the ranking. Some things are not so surprising. So New Zealand, Singapore, Denmark at the very top, that might not be so surprising. Eritrea and Somalia at the very bottom, that also might not be so surprising for the ability of doing business. But you can see that this is not intrinsically correlated with wealth. So Georgia does extremely well, which is a little suspicious because one of the economists in the project joined the Georgian government. But the other one I want to focus on is Rwanda at 29. So Rwanda is ranked here higher than Spain, higher than France, higher than Portugal. So you can see a clear desire or a clear result that does not merely prioritize European over non-European countries. In that sense, seems not to replicate the internal hierarchy of 19th century colonialism in which Europe is at the top of development and others are catching up. Rwanda has surpassed France, which created considerable complaints in France. How realistic is such a list? That is, how much would you really think that you'd rather set up your business in Rwanda than in France? It depends, of course, on many things, but for many purposes, you would go to France and not to Rwanda. So this measures something hypothetical to some extent. It also measures, in the case of Rwanda, the fact that the Rwandan government for some years took these measurements so seriously that they directly engineered their laws so as to fit the indicators of the project, very much like law schools administer their admissions precisely to match the US World News Report. Rwanda did some of that. And you can see on the left, among the improvers, the top 10, the top improver in 2018 was Afghanistan. And as you know, that was not sustainable in the least. So what this measures is not so fully clear in that sense. It tries to overcome a north-south dichotomy, but what it replicates thereby, and that's the even stronger thing, is it rewards not being part of the North, but it rewards adopting rationalities and laws in the way in which the global North emphasizes them. So if you look back to what is being measured here, how fast can you start a business? How fast can you register property? How fast can you get rid of your workers? This is a inbuilt Northern capitalist rationality translated into an objective measurement of what makes good or bad laws. That is, the economists would say, we're not saying good or bad, we're just saying what complies specifically with these requirements. It's not normative in the way in which economists tell us that they're not normative. But of course, the normativity is built into this very rationality. And why does this then break down? Because of manipulations. The first manipulation that I have here is there you can see how the project was biased against the socialist government in Chile. The socialist government did significantly worse than the conservative presidency, even though the measures, the values were the same because indicators were changed. What broke the project was the China manipulation. China was very unhappy about not rising in the rankings, but instead falling. And the risk was that they would drop again in 2017, and China threatened to withdraw funding of the World Bank if they dropped in the rankings. And so a lot of discussion was made about what can we do about that. First, they say we incorporate Hong Kong and Taiwan. And people said that is somewhat problematic from a public international law perspective. So then they said, let's just focus on the most important economic cities. Let's just focus on Beijing and Shanghai. And then someone said we'd have to do that for all the countries, and we have no idea what comes out of that. And so they just then put the indicators. They said, how do we reverse engineer the results so to make sure that China doesn't drop in the rankings by valuing some things very highly that China does well in, and others less so that China doesn't do so well in. And then the rankings were stopped, and the project is now stalled, and the attempt is made to have a better measurement that can't be manipulated so easily, and maybe also to underemphasize the rankings, although the rankings were what made this so successful. Rankings are what people love, as you know. Rankings is what law students love when they have to pick a law school. Rankings is what journalists love when they find these results. It remains to be seen what comes of that. What are problems of this project? Some should be immediately visible. One is the prioritization of formalized law over other forms of social ordering. That is, what is being measured here are formalized legal processes. The way in which I register a corporation, that is, I have to go through the formal steps of registering a corporation, whereas informal businesses are not measured in this context. The very legal origins, what gets transplanted, there we have a legal transfer, were largely formal rules and institutions. And it's not the specific ways in which normativity is created, the specific ways in which society organizes itself. So we have here a classical shortcoming of comparative law, made even stronger by the economists, that is the focus on formal rules over actual processes. In fact, early versions of the projects looked at legal rules and thought that legal rules themselves have impacts in society. Only later did it become clear that institutions mattered as well, but society was not really assessed in this project. Second problem here, methodological nationalism. That is, the focus is largely on nations, on states. How easy is it to do business in China, to use that recent example? But China is not China, obviously. That is, doing business at different places in China has tremendous differences, huge differences, much bigger than the differences between the median of China and the median of some other country. So we have here a problem that also emerges from comparative law, where we compare French law to English law, or Egyptian law to Iraqi law. That is, we focus on nations as our objects of study and compare those. There's a second shortcoming. Related with that is an assumed homogeneity within legal traditions and systems. That is, we assume the entirety of Rwanda to be homogeneous, and that means we overestimate official over unofficial law, majorities over minorities, cities over countryside, etc. So those are three critiques that can fit also in a traditional critique of comparative law. The fourth then is the one where some decolonial approach is entered, and that is the implied superiority here of the global north. What we have here is not, as I said, a superiority of northern laws or states over southern laws or states, but more perfidious, if you want, a superiority of northern epistemologies over southern epistemologies, about northern ways of doing law over southern ways of doing law. That is, to the extent that countries in the global south buy into these rationalities, they can rise higher in the rankings. To the extent that they reject them, they will not rise higher in the rankings. So we have here one classical move of coloniality, that is the universalization of contingent and specific ways of doing law. The second is here the idea of separation. That is, we separate out from each other these individual legal systems, these individual countries. And what the project proposes is the transfer of successful solutions from one system to another. What that means is it separates donor and recipient country. It does so in the colonial context. It says that laws are made in the colonizing country, they're made in England, and then they are transferred to a separate recipient, that is the former colony. And they recommend the same process for law reform today, to say, look at the successful law reforms that Rwanda has made and transfer those to your system in Guatemala or wherever you want to make law reform. And so this is not only methodological nationalism, it also translates into a separation between legal systems, all of which are in reality, of course, connected within a global capitalism. That is, colonial laws already were made against the background of the colonies. There is as we know, a backspill, if you want, from the colonial endeavor back to the metropolis, France, England, etc. These transplants here can only be viewed as separate if we focus only on legal rules. That is, we take the legal rules of Rwandan law and transfer those to Guatemala. That's a clear transfer. Otherwise, the way we understand the diffusion of laws and legal ideas is a much more complex process, much better explained through concepts like entanglement and the like than actual transfers between separate entities. And then the third problem is here an exoticization or normalization of the global south. Exoticization as saying this is other than Europe. Normalization as saying this is the same as Europe. And this is perhaps the most challenging, most problematic challenge for comparative law, because it goes to the core of the problem of comparison. That is, if comparison is putting things in perspective and in relation and understanding the other through the self, then intrinsic in that is always a certain hierarchy. If I sit in Germany and I say I'm now comparing Chinese law to German law, to my own law, I'm immediately making in some way German law the yardstick against which I evaluate China. The yardstick not in the sense that I say German law is necessarily the best law, Chinese law could never be better, because the less German it would be, the less good it would be. That's not what happens. Chinese law may very well appear superior from that perspective. But what I'm doing is epistemologically, I'm defining China, I'm understanding China in its relation to Germany. Whereas I typically don't do the same. I don't understand Germany in the view of China. Maybe from the perspective of China, I would do that, although power imbalances mean that there's less, that this kind of colonial gaze happens also in outside of the global north. But certainly from my perspective in Hamburg, or from the perspective of Chicago, or from the perspective of the World Bank in Washington, that's what happens. That is, the global south is understood through the lens against the perspective of the global north. And it's that process in particular that challenges, I think, the project of traditional comparative law, but also of decolonial comparative law. So the last thought that I want to leave you with here, I jump over all of this, as I said, and also about the responses. I want to suggest this because there is a critique drawing very much on that last point, but also on the colonial origins that I mentioned earlier, against comparison more generally. It is the suggestion that comparison as a concrete project, concrete intellectual project, is about dominating and hierarchizing. It's about hierarchies traditionally. It's about a certain development from earlier stages to better stages, something that we see in the 19th century in colonization, something that we see in the doing business reform, which suggests that the poor economies may improve and thereby come up to the higher economies. And in that sense, it's about a development through certain stages, and it's about hierarchizing, about having those at the top that are successful and those at the bottom that are not. So those are problems, two problems of comparison. The third is essentialization of object, that is, we compare China to Japan as though those were separate objects, despite the centuries-long mutual interactions that existed between China and Japan, to use that that one example. And so some critique of comparative law suggests that we should give up comparison altogether. We should replace comparative law with something different. In the same way in which we can see that comparative history has made place to world history, that comparative literature has been in crisis and has become something else, that comparative law should be replaced with something else altogether in order to account for the demands of decoloniality. One possibility would be transnational law. One would be a focus on legal pluralism. One would indeed be a focus on world law. And one would be a focus on entanglement. We see all of those moves in the discipline. And so to some extent, to come out and say, I want to defend comparative law may seem anachronistic. We think, Lena and I, that comparison is central. We think that comparison is central to a proper understanding of the coloniality of law. Not in the sense that objects have to be viewed as essentially separate, but in the sense that the self-understanding of law has been precisely that. That is, the way in which law looks at itself, global law looks at itself, is through conceptualizing European law as something different from Latin American. And so it is in that sense the self-understanding of law that it creates these very relations of comparison. And rather than denying the fact that this is being constructed within the discipline, we think that it has to be highlighted. What this becomes is comparison, not as mere juxtaposition or as finding similarities and differences. It's a broader concept of comparison that I call here comparison as relationality. But it's important to understand law, we think, as something that does not transcend these separations, but operationalizes them and makes them fruitful. I'll stop there because I've spoken longer than I promised I would, or I didn't promise, but longer than I should have. And instead welcome questions and discussions, not only on the methodological field in general, but also on the specific case study, or really on anything else that interests you from your own particular research.
Great. Thank you so much for this, I think, like thought-provoking presentation. We have entered the Q&A session. We have an international student audience. I'm sure you have a lot of questions. Again, the event will be recorded, uploaded to YouTube, so you can either raise your hand or you can write them down in the chat box if you prefer that, and then I will read your questions out to you. I will insert myself at the queue at one point also, but we start with Simon.
Thank you, Daniel, and thank you so much, Professor, for the session. Very nice to see another former Duke law professor, as I went to Duke for my master's. I have a lot of questions, but I'm going to start with one, and specifically to prepare for your talk, I read your paper that you co-authored. And in your presentation, I can see that. So an important account, I think, in the decolonial comparative law scholarship is about replacing homogeneity with plurality. That concept that I saw mentioned in your paper, and specifically you provided a kind of an example there on international law, and you discussed the concept of Ubuntu, and you stressed about the fact that we're not trying to replace something from the global south. As someone who came from Taiwan, we're not trying to replace something and then as adding it. But then my question lies on that lane on is there any instance where actually something universal actually has to be reached? And of course, in the context of international law, there's the issue of death penalty, gay marriage. And for instance, in Taiwan, we passed the gay marriage law a few years ago, and that's because we recognize that as a human right. But and the concept of marriage, it's itself inherently European centric, and the concept of marriage itself in Taiwan, I think, has a very different meaning. But then we use that as a way to incorporate and legalize gay marriage. So that's like one example. So I was wondering, like, whether like how would decolonial comparative law kind of address this tension there, or if there's no tension, and how we should correctly apply that, maybe in the international kind of law area there.
Mm-hmm.
Thank you.
Yeah, thanks for the question. It's a good question, of course. I want the project to stay away a little from international law, because we have approaches to decolonization in international law already that I would not want to interfere with. I think you gave some of the answer yourself, right? Because on the one hand, you say this is a universal human right. But then on the other hand, you say so much of that is contingent. That is, marriage as such is not, it does not mean the same everywhere. What we find, I think, in approaches to difference is two approaches that are equally unsatisfying. And the one is universalization and the other is relativism. Universalization suggests that on some level, everything has to be the same. And the critique of that, I think, is fairly well known. That is, we can demand kind of gay marriage everywhere, but it means very different things in very different contexts. We have a recent study here at the Max Planck Institute on the global ban on child marriage. And on an abstract level, everyone always agrees that child marriage is bad. But when you look at the specifics of that and the specifics of the ban, you see how contingent that actually becomes. Just as one example, in societies in which marriage is effectively the shorthand as the justification of sexual intercourse, then in that sense, we have child marriage, of course, in American high schools, right? Because it is legitimate on some level for 15-year-olds, 16-year-olds to have sex. And so the comparison there already compares different things. So universalism is problematic. Moral relativism, that's often the critique, of course, of these kinds of approaches, is also problematic. It is the suggestion to say that because Western values should not be universalized, really every society should live by its own values, have its own laws. And the problems of that are obvious as well. One, those laws may also be unjust, even though they're not European. Not everything non-European is great. Second, this does not account for internal frictions and struggles within other societies. Remember the Asian, you don't remember, but you know of the Asian values discussion in the 1980s, 1990s, where it was said that Asians just have different values. They don't cherish democracy and rights so much. And it turned out that especially heads of state in Asia did not like democracy and rights so much. So relativism is also not the way. Both of those are ways of not accounting for relations, right? So universalism doesn't account for difference. Relativism accounts for difference, but does not create relations between the different entities. And decolonial comparative law would have to put these things in relation. So the comparison as such is what puts these things in relation. And I think that's where things become promising. So gay marriage in Taiwan is a mix between a global theme, that is the global movement towards gay marriage, not just as an idea, but as something actually pushed forward by transnational NGOs, and local groups and local values and local contingencies, etc. And so the way in which gay marriage is introduced into Taiwan is by bringing these together. And intrinsically, I would suggest comparative process. The process is comparative in the sense that it compares that which is the model. I say model here to the extent that this is modeled on developments in other countries, compares that with conditions in Taiwan, and uses that fruitfully. So the problem, I think, in some human rights discussions is that this, what Sally Mary has called the vernacularization of human rights, is somehow makes them less pure. Because for some time, the idea in human rights, in the 90s in particular, was that human rights are somehow universal, abstract at the top. And then, yes, they have to be translated down to the local context, but that translation is a deteriorates them. Human rights no longer thinks that, or at least the more progressive human rights scholars no longer think that. Decolonial comparative law certainly would not think that. Decolonial comparative law certainly would think that the universalized standard that exists at some level of abstraction is neither here nor there. It's not very useful for anything. And if it is directly imposed, it becomes a tool of colonial oppression. Whereas the actual translation process, the adoption process as such, as an explicitly comparative process, is the one that makes these things useful and possibly promising. Although, of course, gay marriage is something that we're all in favor of. Anti-sodomy laws have a similar transnational history, right? Where a global standard, a conservative Christian standard, it's translated into local contexts, Uganda, India, etc. And so there's nothing intrinsically good about this process, but it's I think we think both an observation of what actually happens and a promise of how things can be done and how things can be improved.
Vanessa?
Thank you, Daniel, and thank you, Professor, for your very nice presentation today. So I'm going to give you a little bit of context of myself, because the question really points out a future project that I have on my research agenda on decolonial comparative law, legal institutions, and corporate law. And so I'm a JSD candidate. I'm finishing my program and I'm joining the European University Institute. I was trained in Italy, but I'm Peruvian, so it's a kind of complex context. And part of the things that you presented today, such as the Doing Business report, which was extremely successful, because I think it was the first report that actually tried to measure something. And they were not really answering a question in comparative law, but it was much more on deregulation. So the problem that it had is that it touches upon comparative law because you're basically not doing comparative law. So it was not informed. It was a question that was not informed in comparative law. And actually comparativists didn't have probably the elements to do a rebuttal at the time. So we joined later in time to propose an empirical examination of the same legal institutions, but with a comparative framework. And so my point is that when you explain about this project, and I think that it's really a very encouraging project in terms of the scope of the project, because we really start to think in making advances in the field of comparative law. Now, my question is that when you're explaining that comparison is not fading away, my question is who's making the comparison? Because if the comparison comes from an European trained person, then it's going to affect actually the comparison itself, right? I'm not sure if it can change something or it can change that much, because the observation, the benchmark that we are doing, it's also arriving from an European perspective. So what happens, especially in different countries such as Peru or other Latin American countries, is that there is one type of law which is much more similar to European law, which is the one that is a legacy from colonialism, and other layers of law which are less visible because it's much more, they pertain to small communities, to Andean regions where they have their tribunals. Now there is communitarian law within the Andean region. So how are we gonna level up with that sort of problem that exists, because I think that the benchmark still is European law.
Yes, good. That's, I guess it's more than one question almost. Let me try to disentangle if I can. So I would think the doing business project is explicitly comparative. The ranking is explicitly comparative. You might say it's not comparative law. That is, it compares deregulation, levels of deregulation, and not law, to which I would respond that what it compares is deregulation through law, or impacts of law on regulation, on deregulation. And so in that sense, I would say it is comparative law. It's bad comparative law. And so people have said to me, well, yes, that's a bad case study because this is bad comparative law and there could be good comparative law. And as you rightly say, there have been proposals made by comparative lawyers, one group out of Oxford, to have better ways of measuring, to have better ways of empirically measuring laws, etc. And I would say the critique from decolonial comparative law is a more fundamental one that says all of this kind of measuring against one yardstick, all of this kind of ranking is intrinsically problematic because it buys into a logic of hierarchies of different stages of development. And so in that sense, I would say that the critique of the Doing Business report can be translated into a critique also of those more modest attempts to improve that. Now, one important point that you make in that is that of the perspective. You say it's a perspective if a European does it. And of course, you yourself have just described yourself as someone with a complex identity that's in part European and in part not. And so we think, at least Lina and I, the question is less one of actual representation. That is, I am European or you and you are not. But it is certainly against kind of the standpoint to the extent that we come from and represent certain epistemological takes on our issue. That is, to the extent that we are European trained, we tend to replicate European methodologies. And to the extent that you are European trained in Italy or even in Peru, you do the same. And the political, economic, and epistemological superiority, greater strength of the global north over the global south has always meant that those kinds of epistemological takes are replicated within the global south. That is, global southern, many global southern views replicate those from the global north, and especially those that are then trained in global northern places, or that are supported, of course, of a global northern scientific community, tend to be those within that. So that's very hard to overcome. That's the general problem of hierarchies there. One response from decolonial comparative law would be to move away from universalized objective standards towards comparison as relation. That is a relation, in that case, say, between Peruvian perspective and an Italian perspective. And to view that as a relation with two ends. That is, we have, rather than some perspective that transcends those two, we have an Italian perspective on Peru, and we have a Peruvian perspective on Italy. And we have an Italian perspective on the comparison between Peru and Italy, and a Peruvian perspective on that comparison, and a perspective on that very process of comparison, and a perspective on the other, etc., etc. So to try to overcome the problem of universalizing a neutral standpoint would be to focus on the fact that both of those standpoints are contingent upon the other. And the second would be an attempt, and that's harder to do, to overcome this epistemological hierarchy between one and the other, the sense that the European epistemology is going to be so much stronger than the Peruvian one, especially if you focus on the indigena perspective somewhere in Peru rather than the official state perspective. That's much harder to do. And our hope is that the project of decolonial comparative law creates the sufficient openness, the sufficient awareness of that, the sufficient ability to defer and to delink, But I'm not yet sure how successful that can be, because none of that really can overcome the effective power imbalances that exist. So simple example, we have a call for papers for our conferences, and we get high quality papers from the likes of you who are in American law schools. We get low quality papers according to all traditional criteria of what makes good scholarship from the global south. Why? Lack of training, lack of access to materials, or simply different ways of doing research, of doing these studies. That's just very hard. That's just very hard to overcome. We try to integrate those voices because they're important. And we realize that the voices become more silent in the discussions than the global northern voices, because the global northern voices are used to speaking, they know each other, etc., etc. So those are things that I think need to be overcome through openness and through practice, but I'm not yet sure how effectively. But for those of you who apply to come to Brasilia, you can help work that out. I realize I didn't make the pitch sufficiently. I should make that again. The call for papers is on our website, on the Max Planck Institute website.
Yeah, thank you. So unfortunately, we have run out of time, which is on the one hand.
I apologize.
No, that's fine. I work on the relevance of positionality and perspective to the comparative method. So your last answer gave me so many more follow-up questions. But on the other thing, that's a good thing, because it meant we had a great presentation and discussion. Before I let you all go, I would kindly ask you, if possible, to turn on your camera so we can take a picture for our social media. I think Simon will do that.
Thank you, Daniel. Can you all please turn on your camera, and I'll take a picture for all of us while Professor Michael shared the link in the chat. All right, I'm gonna take a picture. 1, 2, 3. Let's do another one. 1, 2, 3. Okay, thank you. Thank you very much.
Great, thanks. So we, by the way, we also, I think, shared already the call for paper through our channel. So I hope you get a lot of good quality people applying. So thank you again, everyone, for attending. Thank you so much for the talk. Our next session will be in 3 weeks on September 19th. We will host Professor Adam Seiss, who will speak on mechanical jurisprudence today and teachings on the relations of science, law, and life. Again, it was very nice to see you all today. Thank you so much, and I look forward to seeing you all during our next event.
Thank you. Thank you very much. Bye-bye.
Thank you. Bye.